Some lawyers said that they were prevented from delivering statements and announcements because the time was not right. I haven't been really able to identify the provision which says when to make what motions. In our law in Poland, there is time for certain motions. But what I saw in your legislation, that there was no time, specific time for various motions. So apparently the judge would say that there will be time for your motions, and then there was no time found at the end. Apparently different motions were also treated differently. Motions concerning defendants were dismissed or referred to a different time, while motions for disqualification of the judge were considered and rejected or dismissed. So that's another thing. And another thing was the lawyer's participation in the trial. This obviously relates to the access to courts. Because they refused to participate in the procedure at the very beginning, they were not allowed to go in. Sometimes they would not be there because they were not informed the right way. Sometimes because other hearings were overlapping. And even though everyone knew sort of where the cases would take place, they would still assign hearings to the same time to prevent lawyers from participation. So these were some of the issues that we noted. I guess this is no surprise to you, perhaps it is, but I suppose this is no surprise to you. And if it's no surprise, then perhaps we can talk about it, what to do further. And another point that I want to make, that all of the problems with the right to a fair trial, and also problems concerning access to courts, to me, are deeply rooted in the crisis of the rule of law and the problems of the judiciary in Armenia. At least this is how it was presented by some lawyers. And this quote, I think, is quite telling. We have good laws and imperfect laws, but it does not matter if we adopt good or bad laws, because the good laws are not applied anyway. In the Sasnatsreli and Sefilian cases, the quality and level of our judicial system has been damaged. And there was a lot of distrust, really amazing distrust of the judiciary among lawyers, and I think this is not an ideal situation. I know this from experience now, unfortunately. So this distrust is not something, it's not right, because lawyers are part of the administration of justice, judges are a different part, and they have to work together independently of the executive. So I just leave it here, that we see that this is part of a big problem. Okay, and now we can move to another very important thing that was mentioned actually in the statement, the Civic Solidarity Platform statement, disciplinary proceedings. And what we noted here is a couple of issues. Unprecedented use of sanctions, in particular. And we understand that this is not entirely up to the Chamber of Advocates, and that this is usually because there is a lot of judicial sanctions and that they are required to initiate proceedings. Although there is some doubt as to whether they are required, but I wanted to show the statistics that we obtained from the Chamber of Advocates. They don't show everything, as you can clearly see, because the columns are empty, but the first line does show the prevalence of proceedings, disciplinary proceedings. 39 to 56 to 91 in January, September. I think it's a clear rise, and among those, 65 were based on judicial motions, judicial sanctions. So what happened? That there are that many sanctions, right? What happened to lawyers in those Sasnatsreli proceedings that they are so, I don't know, naughty perhaps? But this is a clear question. And as I said, to be fair to the Chamber of Advocates, if the rule is that the judicial sanction initiates disciplinary proceedings, there is not much to do. But perhaps Nina and Arek will or Protection of Rights Without Borders can intervene whether this is really the case. We were told that the Chamber of Advocates has to initiate proceedings when there is a judicial sanction. Okay. Many of the proceedings that we talk about here, that refer to lawyers and licensed cases that we noted during the mission, they were not yet, they were in progress, initiated, but things were going on, so we don't know, I don't know how many of those were dismissed and what was the result, and perhaps my colleagues can add to it. Okay, but why were these sanctions applied, and what we think about it? So they were applied for absence from courtroom and for activity during the hearing, obviously. And the absence was related to sanctions against defendants, as we saw it. When the defendants did something, for example, intervened, the judge would not agree with that or would not allow it, then they were out of the court, and the lawyer would leave because they felt obliged that they cannot represent. And then sanctions followed for absence from courtroom. And as a result of searches, the lawyers were not able to participate, then sanctions would be also imposed. And that would result in the initiation of disciplinary proceedings. Also, for activity during hearings, one of the lawyers said that because she so persistently wanted to make a motion which concerned the health of her client, she was also sanctioned. I'm not entirely sure whether this is the right basis for sanctions, but what I believe to be the more serious issue is that it seems to be so massive that it is that it is perceived, at least, as a strategy to discourage lawyers from discharging their duties, actually. And if this is the case, then this is also a danger to the right to a fair trial, right to be represented by a counsel of your choosing, because the defendant has a right to be represented either by himself or by a counsel of his choosing, as I said. When, to my understanding, when the lawyer left, sometimes the judges would impose a public defender, and the client would not like the public defender. The relation between lawyers and clients is based on trust. So it is a dangerous situation to me when when you have a lawyer whom you cannot trust. And there was a lot of distrust expressed during our interviews towards the public defenders. We perhaps would have to talk to clients. We didn't have the chance to talk to public defenders, although we wanted to. But we didn't get a chance. So we didn't hear the other side. I suppose not all of them are to be distrusted, perhaps some of them are to be distrusted. But in this case, if a defendant has his own or her own lawyer, and there is no particular reason, pressing issue, why they cannot use the assistance of this lawyer, they should be able to retain this lawyer. So only important reasons can make the judge change the lawyers. And for example, because certain particular information are required, the lawyer has to be a specialist in a particular field, but this wasn't the case here. And obviously a lot of distrust was expressed towards the independence of the Council of the Chamber of Advocates. It is paramount that any what is it called? Self-professional organization that represents a group. I forgot the word anyways. Self-government, yes, self-government of lawyers is paramount, that it is independent from the executive, from any influence, even from judges. So this is also something that should be resolved. And the last part, persecution outside courts. And I want to make it clear that there were not many cases where lawyers were persecuted. Not many lawyers mentioned that. But those who did mention that, mentioned threats via social media, mentioned surveillance, or at least suspicion of surveillance, and mentioned warnings from various persons. And this cannot happen. I mean, this to us is, even though not frequent, very dangerous. And even if there are only a few cases, if there are few cases of such situation, this is a danger to lawyers, to their clients, to the right to a fair trial, and it should not be tolerated because the state shall ensure that lawyers are able to perform all their professional functions without intimidation, hindrance, harassment, or proper law interference. So, what does it mean? It means that there should be a proper institutional environment which allows them to work independently and safely. Even if there is one case, this case shall not be refraining from interfering with the lawyer's work, because lawyers should be independent and work in the interest of their clients to protect the right to a fair trial of their clients. And by that, the dignity of their clients, I want to say. And any complaints that are made should be investigated promptly and thoroughly. They cannot just be dismissed because there is no data. And then the people who are responsible for any intimidation, any persecution should be brought to responsibility.